Let's talk about it with trial attorney Michael Jaafar. He is in Detroit, Michigan, and up in Minnesota is Jack Rice in St. Paul. All right, guys, this one is, it seems like there's a lot there, and the reason, the defense points out no fingerprints on the dumbbell, but his actions, he takes his ankle bracelet off and flees. I don't know, I'm not seeing a huge opening here, but your thoughts, I'm eager to hear what you guys think. Michael, you first.
Yeah, I mean, clearly this man has gone through something, mental health issues or some sort of a breakdown. I mean, to steal it from your clients is the most sacrosanct responsibility you have as an attorney, is when they trust you with your money. So he stole their money. He pleaded guilty to stealing their money. It's right in keeping with him basically going down this dark path, killing his mom. I mean, it's shocking, but when you hear about it, it kind of fits. The prosecution has presented some pretty good, compelling evidence. I think this guy's going to get cooked. It's very sad. Everybody loses in this. There's no winners. No matter what happens, whether he's acquitted or not, everybody's a loser in this situation. It's very sad. It's very disappointing. He killed his own mom. If that's in fact what happened, it's very sad to see. And as a fellow attorney, I can only look at that and say, wow, that's the worst possible case scenario for your career and life to end.
Jack, as Matt pointed out, a lot of Murdoch vibes here, where you're stealing money and then you kill a loved one, and the defense is, oh, he would never do that. Your thoughts?
Yeah, you got to separate the fact that he's a thief, the fact that he's a liar, from the idea that he's a murderer. I mean, that really is the necessity here, because as your previous guest just described, what happens when you have somebody who is charged with this, who is also an attorney? He's going to be hated at a level that you're not going to normally see from a defendant, and then you can take that hate and transfer it and simply say, somebody who would actually steal from his own clients, you can't trust him in any sense of the word, so therefore he could have done this as well, or he did do this as well. He's going to have to take the stand, I think. And he's going to have to be able to take the stand so he can argue, yes, I was this horrible thing. Yes, I stole from my own clients. Yes, I had this reason and that reason and the other. It's not justifiable. But that is much different than the relationship that I had with my mom. I would never do such a thing. He has to create that gulf. If he doesn't, as you just heard, he's cooked.
Yeah, boy, and just like Murdoch, he took the stand there. Difference here is the details of the theft from the clients, which was allowed in Murdoch's case, where juries heard days and days of that testimony. You won't have that here, but they do know that it happened. Okay, right before this started, the defense attorney articulated to the court there's a position, or there's time in my questioning I can't go forward because of ethical concerns. Michael Jaafar, Jack Rice with us. Michael, what do you think it is?
It could only be one thing. That defense attorney was in a difficult spot, and he knew that his client was going to perjure himself. And people don't know this. For lawyers, we're not allowed to lie in court. Not only are we not allowed to lie in court, we're not allowed to allow our clients to lie in court. And if we know that our clients are lying in court and perjuring themselves, we have to do, I can only say this, we have to kind of like embarrass our clients at the court and say, hey, to correct the testimony, it's not correct. I know it's not correct. Otherwise, that attorney will lose his license and his career is over. So it can only mean that he must have known his client was going to perjure himself. My old mentor used to say, as an attorney, you have to hold your breath every single time that your client opens his mouth to talk. And that lawyer looked like he had a weight on his shoulders. And for them approaching the bench right now, I could only assume it's because the attorney is going to warn the judge, look, if he perjures himself on cross, what am I going to do? Am I going to stand up and object and say he's lying? So this is a very, very, very tricky situation.
Jack, I may have to cut you off, but your thoughts?
Yeah, this is the challenge. We're talking about his obligation to his client on the one side. He has to do that. He has to continue to do that. The conflict can happen when there's actually a candor to the court requirement as well, and there always is for attorneys. They have to be able to tell the truth, and they also have to make sure they're not perpetuating a fraud or a lie that comes from their client. And so you're struggling because they actually can be in conflict. And the struggle right now is, how does this man speak to a jury if there aren't any questions asked? And the judge was trying to drive this and say it's going to go to cross, which means he then couldn't actually say to the jury what he wants to say. What makes this interesting in my head is, I thought to myself, what would happen if this defendant right now, if Mr. Zeiler right now fired his lawyer? If he fired his lawyer and he said, I want to go pro se, represent myself, can he then take the stand and speak for himself? I think that may be the only way he's going to be able to do this thing, because again, if he's going to lie, his lawyer can't do it. And if he doesn't have a lawyer, it may be the only way that this guy can actually do that.
Yeah, and I don't know that he knows that that's on the menu for him as a possibility.
True.
There's just one camera in this courtroom, so it's hard to tell if this sidebar has broken up, because we're looking at,
Ladies and gentlemen.
Jaafar, Jack Rice with us. Jack, what'd you think about the end there of direct? Obviously, they worked a way out so that the attorney could ask a question to get him going down that path, what he wanted to go down.
I think it was a combination of what his attorney was wanting and also what the prosecutor was wanting. They didn't want him to completely go off the rails and do something on his own either. So if you actually notice the question, it was really, the term would be non-responsive. He asks a question and he kind of goes off the rails on his own, but he's still sort of in place, and the prosecutor didn't object to it, and they allowed it to happen.
All right. Okay, sidebar. Jack Rice, Michael Jaafar. Michael, you first. Thoughts on this cross?
I mean, short of his client admitting to the murder, this is going sideways. This is what you're witnessing here is a legal version of a train wreck. Mr. Zeiler is destroying his credibility. He's destroying his ability to stand in front of this jury as an innocent person. He's taking away many options for his defense attorney. In the closing argument now, the prosecutor is going to be able to say, look, he lied on the piece of paper. He lied and when he wrote the letter. He lied about where he was. He lied about being in court. He cannot be trusted. And also the guy just seems like he's disturbed, right? So, I mean, when you're a juror, you're a human being. You look at the person, you size them up. Until now, they have not heard Mr. Zeiler speak. They had no idea what type of person he was. They're kind of seeing now that this is the person that's charged. This is not boding well. The defense attorney, I feel so bad for this guy. I mean, he's got such a major challenge in front of him. The rest of this case is going to be miserable for that team.
Jack?
The prosecutor is struggling because of how this man is responding. When you're cross-examining somebody, there's a couple of things you got to think about. You got to narrow your questions down. You need to be extraordinarily specific. So in other words, you might start with something like this. Mr. Zeiler, I'm showing you a document. This is your handwriting. This is something you wrote on this date. This is what it says. I'm going to show you another document from Maryland. Recognize this document? It was provided in discovery. You were never arrested in Maryland. You were never in custody in Maryland. Move on. You see how tight that is? It's always about creating a definitive answer so you force him down a path, because he continues to equivocate. Now, sometimes you want that because it makes him look like a liar. It makes him look like he thinks he's the smartest guy in the room and he's winning, when in fact he's alienating everybody, including this jury. So it sort of benefits both directions. But I think the prosecution needs to be more careful in terms of how they control this guy, because when you control them, you get out of them what you want versus giving them room to provide what it is that they want to provide.
All right.